And please take the slide down, and then I'm going to hand over to our moderator today, Favour Ime. Thank you.
Thank you very much, Isabel, and thank you, esteemed colleagues, ladies and gentlemen, for joining us today to celebrate International Anti-Corruption Day with this important event. I will start by saying that in our experience at Open Ownership working in this space, specifically beneficial ownership transparency, we have seen a recurring challenge, one that I believe that most of us would agree with. And it's the fact that even when governments and institutions are deeply committed to transparency, the complexity of drafting effective laws often slows down or even stalls progress with the implementation of BOT. And colleagues, this isn't unique to any one country. It's actually a universal challenge that we've seen in different continents, different parts of the world. And it's one that requires a combination of expertise, bold action, but more importantly, collaboration, which is the reason why we're here. We're here because open ownership in collaboration with the National Democratic Institute and the Extractive Industry Transparency Initiative have come together to develop 3 new resources to assist colleagues like yourselves who are in the front lines of this work. I'm pretty sure you already have access to the resources as it was shared as part of our invitation, but I'll just quickly read them out. The first resource that was published by Open Ownership is the Guide to Drafting Effective Legislation for Beneficial Ownership Transparency. The second one, which was done by NDI and Open Ownership, is the Beneficial Ownership Transparency, a guide for parliaments. And then the third one, done in collaboration with EITI and Open Ownership, is Legislating for Effective Beneficial Ownership Transparency Reforms in the Extractive Sector. So we all, as different institutions, appreciate that this is quite a complex topic, which is why there is this collaboration to really think about what audience we need to be engaging with, what sort of content in a contextualized format do we need to share as it relates to effectively legislating for BOT. And you have that broad a resource that Open Ownership has published. You have a resource that is tailored to parliaments because eventually, even though we have implementers drafting the laws, it would have to be tabled before parliament. And then we have a resource that is tailored to countries that are implementing the requirements of the EITI standard, especially countries that have to grapple with natural resource governance issues. So you can sort of see the thoughts, the careful thought here in terms of the collaboration between the 3 organizations in the room today. So thank you so much for joining us. Colleagues, these guides are designed to equip policymakers, civil society organizations, legislators, and advocates, some of which are joining us today, with the tools that they need to navigate the complexities of beneficial ownership transparency reforms. And today we will hear from legislators and experts from around the world sharing their experiences and insights. And we will also explore how these resources can help turn ambition and commitment into action and also foster transparency that drives accountability, equitable tax collection, and ultimately good governance. So let's dive in. In terms of the order of discussion for today, we will start by an opening remark by a distinguished speaker who will be joining us today. I will introduce him shortly. And then we're going to hear perspectives from our collaborators, as well as implementers from Philippines and on the other side of the world from Zambia. And then we're going to open the floor for a discussion session so we can really talk a lot more about what this means for our respective countries and the work that we all do. So thank you once again, esteemed colleagues, distinguished ladies and gentlemen, for joining us today. And I have the honor and the pleasure of inviting for the opening remark, Senator Luis Donaldo Colosio, who is the president of the Digital Rights Commission in Mexico, and he will be sharing the opening remarks for today. Senator, the floor is yours.
Thank you so much. Everyone hear me? Thank you so much for the invitation to speak at this event. I'm quite honored to come here, both as the president of the Commission of Digital Rights for Mexico but also as former mayor of Monterrey, Nuevo León, in which I was more than sure and I was adamant that adequate legislative reform in order to bring forth technological changes was not only necessary, but it was paramount for a correct implementation of an anti-corruption basis in our government. Right now in Mexico, we're living a bit of a setback, troubling times, because it's very significant to point this out, because there's right now certain administrative changes that have been going on that has been eliminating some constitutionally autonomous organisms, which their nature is technical and not political. And their elimination represents a step backwards into centralism, authoritarianism, and human rights violations. This institutional weakening and affecting key economic areas of the countries, well, and especially in the digital spectrum, well, this makes corruption, well, the combating corruption will necessarily be more difficult in our country. What we need to do is make sure that the laws that we are trying to implement, the laws that we are trying to make into effect, do not stay as dead weight or dead or only in paper, because the application of discretionality in legislation sometimes is much more, well, grave than you would if you didn't have these laws in the first place. So the opportunity that we have in our respective countries is the advancement towards a digital government in order to implement safeguards with technology that can help us and our countries to better implement transparency with key anti-corruption technologies that serve a better purpose and no discretionality agenda than we human beings that are flawed. In the digital spectrum, we need to generate advancements that take benefits like reduce corruptions, that help us take down costs, that help us reduce timeframes in order to have our public administration in much better shape. I remember a few years ago when I was about to become mayor of the city of Monterrey. I was watching a TED Talk with one of my coworkers, and we saw the example of the e-government from Estonia. Immediately, I called up. I got my phone, and I called another one of my coworkers. She was going to be my secretary for innovation and open government. And I sent her this video, and I told her, you need to watch this. This is exactly what I want for our city. We need to implement these safeguards and these technologies that not only help us better administer the city, but it helps us implement these safeguards that are going to be human-proof. And that is what we need to strive for. Most of these technologies which are already available in the market for both governments and companies are just needed to be pushed with a little nudge into the legislation to make them not only available for governments, but not optional. And that is the key. Because sometimes when you try to implement these new things, sometimes when you try to push boundaries in order to implement new processes, both in the public and private sector, you will get a lot of pushback. You have no idea. It doesn't matter if you are the chief executive officer or the mayor of the city, you will get a lot of pushback from your subordinates if you try to implement these new technologies. And these new technologies, they cause for certain practices to be abandoned. And that is the natural way of things. And it is, of course, sometimes something that we all know that is going to be happening. We all need to fight against. but it's not necessarily by just strengthening or toughening the punishments that you are going to get results. This is nothing more removed from the truth, because we've done that in Mexico, and not only has it proven inefficient or inadequate, it's again this discretionality of the application of the law that doesn't help anyone, that sometimes, or many of the times, keeps prevailing. So it's not only the punitive side of the law that is going to make this work, but it's also the re-engineering or reimagining how we construct the relationship between the end user and their government, the end user and their companies, and how we allow their integration in the legal order to be published. So that is why the strengthening of the internal organs of control, for example, what we did in Monterrey, in the city of Monterrey, allowing a new system of public how do you say it? Excuse me, for denouncing, for strengthening our internal Contraloria to present anonymous denouncers. And in order for this to work, you need to allow people to trust the system. And if you don't make your system of public appeals as a strong, solid system, people are not going to trust it. You need to see to it that people can safely interact with the system, and they need to see results in order for them to use it. So for that, you need to strengthen the legislation in personal data, in privacy, in intimacy, in digital identity, and obviously the right for getting in certain intersection and use of social media. This is something that has been overlooked in many countries, and many people do not trust these systems because technologies leave us exposed nowadays instead of protected. So our job as legislators, as parliamentarians, should be to utilize all these technologies to protect our users, our end users, in these interactions with their governments or with their corporations, and for them to be able to trust the system in case they have something to denounce, in ways that they will be protected and the system will work for them. And for this case to work, really, we need to process our laws in order to incorporate these technologies and also the automation of processes, because this is something that will help us in the pursuit of an anti-corruption basis. This will help us in the pursuit of an anti-corruption basis in order to make these systems work for us in ways that transparency and also justice will be served without the human element of discretionality. Right now in the Mexican Senate, we are trying to strive precisely for these technologies to be applied in a wide range of governmental agencies and municipalities around the country, in order for all these institutions to be able to take these technologies and implement them freely. Because right now, what we need to start working on in many of our countries is having, from the beginning in the constitutional framework, the necessary technological tools available for us to be able to incorporate these technologies and present them to the public in a safe way for them to use, but also in a good collaboration with the private sector in order for these new technologies to be incentivized, in order for them to be continuously being pushed towards striving towards a better services. Otherwise, if we have legislation that's too limited or punitive, not only are we not going to take full advantage of all this that's going on in the technological market, but we're also going to be we'll slowing down this evolution that we could be having that could be helping, that would be very helpful for us in the near future. So electronic government, digital governance can offer in about 99% of all public services and make them available in a very safe, in a safe use in questions that could protect your identity, your administrative ambiance, and interoperability between databases and platforms. So those are the things that we need to take into consideration whenever we want to try to put this into effect in the law.
Fantastic. Thank you very much, Senator. You said a lot of things there. I was just taking notes, but I think what I would say that stood out to me is your point about it's not so much about strengthening sanctions and making them more punitive or more dissuasive, as Fatah would put it, but it's really, like you said, about re-engineering how
Exactly.
you relate with the end user of that law. So your companies, the customers, whoever it is, your lawyers and accountants that would interact with that law. What is the relationship between the person drafting the law, the agency authority, and the people that are actually going to respond to the legislation? And really, this is all about trust. If you're able to engage with them, make them understand why you're doing this, get their inputs, then that user-based approach would mean that most likely they would at least comply to a certain extent with whatever legislation you are putting in place. I think that's a very critical point there that you've raised. Yeah, so thank you so much. We really appreciate you sharing those critical points and opening up today's session for us.
It's an honor. Thank you.
The time. All right, then thank you. So we'll proceed to another remark by one of our collaborators, which Open Ownership works a lot with. It's the EITI, and I'll very gladly invite Gay Ordenes, the technical director at EITI, to share very quick remarks in 5 minutes so we can proceed. Thank you. Over to you, Gay.
Thank you very much, Favor, and I hope you're hearing me okay. So we would like to welcome everyone to this event. I'm very pleased to see your interest in the publication that we are launching today, Legislating for Effective Beneficial Ownership Transparency Reforms in the Extractive Sector. The EITI has been working on the issue of beneficial ownership transparency since 2013 as part of our efforts to combat corruption in the extractive sector. It has been quite a journey from doing a pilot of BO disclosures in a few countries in 2013. We have seen beneficial ownership disclosures grow over the years, and currently we have 30 EITI countries disclosing beneficial ownership information of companies in the extractive sector, either through central registers or through EITI reporting processes. Some of these reforms on BO were catalyzed or complemented by the country's commitment to implement the EITI standard. What we have seen, however, is that although voluntary disclosures are welcome, legislating beneficial ownership reforms ensures more compliance and more high-quality data. The publication we are launching today provides practical guidance and examples of best practice for legislators on how to institutionalize BO reforms through laws. It is a product of EITI and Open Ownership's engagement with legislators and other policymakers in countries. So I wish to highlight a few key messages from this publication from an extractive sector governance perspective. In resource-rich countries, BOT, or beneficial ownership transparency, is crucial in ensuring sound management of the extractive sector. Knowing the individuals involved in business transactions between companies and governments is crucial for screening investors and informing decision-making on potential business relationships to combat corruption. The global energy transition is ushering a shift in demands for oil, gas, and minerals, which could exacerbate corruption risks in the sector. Beneficial ownership transparency plays a pivotal role in ensuring that the benefits generated from natural resources reach citizens who are the rightful beneficiaries of these resources. Sectoral data on beneficial ownership for sectors that are prone to corruption, such as the oil, gas, and mining sector, could help investigate corruption, track financial flows, prevent conflicts of interest, highlight irregularities, and improve due diligence and sanctions screening. Allow me now to share some data to emphasize the importance of some of the key points covered by our publication. Based on a stock take that the EITI conducted this year, 60% of the 56 EITI implementing countries have established a legal framework for beneficial ownership. 84% of these countries have adopted a definition of beneficial owners in compliance with the EITI standard and other international norms. 80% of EITI countries have established a definition of what constitutes a politically exposed person for BO declaration purposes. And 90% have defined specific thresholds for disclosure. But while all of these are positive trends, there's still much work that needs to be done. For example, only 60% of EITI countries have incorporated reporting obligations for politically exposed persons in their disclosure frameworks. Reporting thresholds, only half of all EITI countries have set their threshold at 10% or below, which is what the EITI is recommending. 30% of countries have thresholds set at 25% or higher, including all members of the European Economic Area. I mentioned earlier the EITI is encouraging to adopt a threshold of 10% or lower, given the types and level of risks associated with the sector. It is widely recognized that higher thresholds increase the likelihood of inadvertently excluding beneficial owners from the scope of reporting, thus limiting the potential of using BO data for investigation. In a sector such as mining, oil, and gas, where large amounts are at stake, even a 1% ownership could amount to millions of dollars. In view of this, the EITA encouraged the adoption of lower thresholds. And lastly, with regard to approaches to disclosure, we found that only 34% of EITI countries, 15 in total, have publicly accessible registers, either through central registers or EITI reporting. Of course, we still continue to observe that comprehensiveness of disclosed information remains a challenge, specifically on the compliance rate of reporting companies and the level of detail that they report. And more importantly, legal barriers continues to pose a challenge to the public disclosure of BO data in some EITI countries. So the current landscape that I described globally underscores the need for legislation of BO reforms to ensure the following. First, that there are no legal barriers to data collection and public access. Second, that there is standardization of how data is collected to ensure usability and analysis. Third, that adequate measures are adopted to ensure high quality of data. And lastly, to strengthen the enforcement of BO reforms through appropriate sanctions. The publication we are launching today discusses in detail how to ensure that these measures are in place, and we hope that the practical guidance it offers would be useful for legislators and policymakers who are working to strengthen BO reforms through legislation. So to end, I want to thank you again for your participation in this event and for being leading reformers on beneficial ownership transparency. The Opening Extractives program through the EITI and Open Ownership are pleased to join you in this journey. Thank you.
Thank you very much, Kay. I really like the balanced approach you've taken there in highlighting, the positives, the progress that countries have made, but also where the gaps are and how the publications can actually help countries to work on some of those issues you've raised, for instance, thresholds, definition, the comprehensiveness and quality of the disclosures that are being received by the relevant authorities. I think it's critical there. And I think another thing that you've done very nicely is to remind us of the importance of this conversation as a whole in terms of the value of if this is done well, we would have quality information to improve, for example, due diligence in license screening processes and generally natural resource governance. I think you're preaching to the converted there. I think we all very easily agree with you. So thank you very much for sharing those points and just highlighting some of those critical value add there for BO information. Appreciate that, Gay. Thank you. So we will proceed now to our next speaker. That's from NDI, our other collaborator on one of the pieces that we're launching today. To get our perspective, I'll be inviting Karina Ribagia, a senior advisor for anti-corruption from the National Democratic Institute. Karina, I will hand over to you now. Thank you.
Thank you so much, Favor. And Thank you everyone for joining us, and in particular, thanks Open Ownership and EITI for the great collaboration we had with this event. We're very excited about the launch of these 3 resources, and of course, particularly excited about the guidance on BOT for parliaments. As many of you may know, at NDI, we work a lot with parliaments and are very sort of concerned in how to better engage and fortify parliaments as an institution. And we work with the different actors within parliaments, both MPs and staff, political bodies, and technical services on issues related to open government, corruption prevention, and democratic delivery. So why a special guidance on beneficial ownership transparency for parliaments? Well, first, this is clearly a reform area that cuts across many policy concerns. We've just heard from Gay about the importance for transparency in the extractive sector, but it's also really important in strengthening transparency in how government collects or spends money. It can prevent corruption and illicit financial flows, and it can enhance integrity and accountability for holders of political office. I think we've seen around the world that parliaments have not been as active as they could have been in spearheading some of these reforms, debating them, and tracking them. But parliaments are representative bodies, and they are essential not only in ensuring that reforms like beneficial ownership transparency respond to a variety of concerns in society, but also that these reforms have the democratic legitimacy through transparency and public consultation, democratic debate, and holding government accountable. Some of these principles, the previous speakers have also referred to. And third, actually play a role internationally. For instance, within platforms like the Open Government Partnership, which, by the way, has been a driver for BOT reforms in many countries, including 2 that are represented on the panel today. And especially when it comes to transnational illicit financial flows, where beneficial ownership transparency and transborder collaboration are instrumental, parliaments have perhaps a less explored role in facilitating these global conversations and reforms. So needless to say, parliaments are crucial in shaping a robust legal and regulatory framework and ensuring that standards are not only established in law, but also adhered to in practice. And the guide that we are launching today is really meant to assist MPs and staff in navigating the different policy objectives and use cases and the details of, as Faber was mentioning, of a complex reform. But parliaments can also benefit from beneficial ownership data in their own work and strengthen their ability to perform their oversight function. And so the guide also presents the tools that ensure that parliaments can track how these reforms are being implemented and offer insights as to how it can be useful to them. So what you'll find in the guide is a bit of a deep dive into legislating for BOT. What are those key elements or standards that need to be included in legislation, mostly primary, because that's where parliaments come in, but also secondary legislation. I won't go over all of the elements. I think we've already discussed them a little bit previously, and then you'll find them in all of the 3 resources that are being launched today. But I will say that regardless of the type of the legal system, what's central to the success is to be clear about the objectives and have consistency in law on how these objectives can be achieved. Where there are genuine domestic policy objectives, it could be public procurement, it could be transparency in the extractive, it could be tax collection, then legislation will be more effective. And so that includes also how we define beneficial ownership across relevant legislation, how we set the threshold, as he was mentioning, and so on. And then, of course, establishing the register and allowing or creating sound mechanisms for accessing information. And that's really important because access to beneficial ownership information and making that as wide as possible is really important for all of those policy objectives that we've been discussing so far, and ensuring integrity in government in particular. And in fact, parliaments should be among the stakeholders in accessing that information. Now, well, obviously these are resources that really focus on guidance for how to legislate on beneficial ownership transparency. There's the other component and the other important role for parliaments, which is oversight. And I think, there are interesting questions being raised about the effectiveness and the impact that beneficial ownership transparency reforms are having. And I think parliaments can actually play a really important role here. And obviously it does not stop at legislation. So MPs have actually a variety of tools at their disposal to assess the implementation of these reforms, through budgetary oversight, through questions and interpellations, through committees of inquiry, reports, requests for information from responsible authorities to assess impact and understand how these reforms are playing out in practice and the benefits that they're bringing. And of course, working with civil society and experts, and overseeing how secondary legislation is drafted. So how are the implementers actually putting this into action, into force? And I think, for instance, the way the reform is being implemented currently in the US, I think that's a really interesting case in point. Now, there isn't a lot of evidence worldwide as to how parliaments are conducting this type of oversight. And that's also because this is still a relatively new reform and countries are still sort of learning. But I think their importance is very clear. And the guide presents all of these entry points for parliaments and how it can hold government to account for how it implements beneficial ownership reforms. And lastly, as I mentioned, parliaments should be among the users of beneficial ownership information, because this can really make their activity more impactful in various domains. They can leverage it for diverse oversight activities in many sectors. They can use the information when assessing candidates for high-level offices, for instance, by verifying the accuracy of their asset disclosures. Of course, if legislation provides the collection of information for politically exposed persons. They can use it to understand industry, competition, or to scrutinize public contracting projects or conduct national security assessment. So I think there's a really expansive role here for parliaments. And with this guidance, we're hoping to raise awareness, but also offer some of the technical tools through which parliaments can play a more active role in working towards implementing sound BOT reforms. So I hope you'll find this guide useful, and please reach out to NDI and Open Ownership with any feedback you might have. Thank you, and I look forward to the discussion.
Thank you very much, Karina. I think you've really amplified the unique role of Parliament in the conversation. And for some reason, I think we haven't really spoken a lot about the role of Parliament. When you look at the pool of resources that exist, the technical assistance that is delivered globally, you would see that there's a lot of focus on implementing agencies, your corporate registries, your FIUs, and the likes. And it's for good reason, because they have that statutory mandate to actually create registers, collect information. But I think we're beginning to appreciate that this is a value chain. And if you just focus on one aspect of the value chain, you probably won't get the value that the chain is supposed to provide, to everyone that is a part of that. So I think it's critical for you, which you've very nicely done, to amplify some of these key things that parliaments could do beyond even contributing to the debate around this, approving the legislation, but to oversight. And truly, how can they utilize the oversight functions that you've mentioned if they're not engaged, in this process? So I think it's really critical, the points that you've raised there. So thank you very much, Karina, for flagging that. All right, colleagues, are going to proceed very quickly, and rest assured, in 20 minutes, we're going to open the floor. I know some of us are buzzing with some questions that would like to ask. But before we get to the Q&A, I'm just going to invite perspectives from two countries, Philippines and Zambia. We'll start with Philippines, and I'll be inviting with pleasure Attorney Daniel Luis Macalino. He is the officer in charge of the Anti-Money Laundering Division for the Securities and Exchange Commission in the Philippines. We've worked a lot with Attorney Daniel, and it's always a pleasure to have you engage with us. So I'm going to hand the floor over to you to share your perspective on the conversation.
Hello, thank you, Favor, for that. And good evening, everyone. Good evening from the Philippines. And it is my privilege to share our journey in legislating and in implementing beneficial ownership transparency reforms. In this important International Anti-Corruption Day celebration, the beneficial ownership transparency or corporate transparency for that matter has since become a cornerstone as far as we're concerned in combating corruption and fostering good governance. And we are privileged to share the lessons we've learned, the challenge we've faced, and the strategies that shape our progress. So in the Philippines, our BO reforms are rooted in essentially two primary legal frameworks. First is the Anti-Money Laundering Act, and of course, the one that the SEC implements really is the revised Corporation Code. And this is supported by an executive order from our president himself, showing the top-level commitment, which provides the whole of government approach for the AML CFT strategies of the country. Of course, I think everyone would know, or some would know, that the Philippines is currently on the gray list and hopefully will exit next year after we have already addressed our action items. So our journey, while it is an advocacy, was initially fueled by necessity to get out of the gray list, of course. So the Anti-Money Laundering Act and the revised Corporation Code empower our commission, the SEC, to promulgate rules and regulation for beneficial ownership transparency. As the SEC collects BO data from corporations through the General Information Sheet, which has long been in a corporate practice in the Philippines. So we have leveraged this practice to include beneficial ownership information, which is now uploaded online and shared via secure data sharing agreements. So one lesson that I can share here is that by placing authority to a government agency that already has the expertise or has the background to maintain this system is a bonus, because the SEC is the company registrar here in the Philippines, who already have the experience of running a registry even before the BO reforms were introduced. So our regulatory approach reflects our commitment to FATF standards and addressing specific contexts in the Philippines where, for example, enactment of laws in the Philippines can take really a long process. In fact, just an example, our corporate law or corporation law was it took 4 decades for it to be amended in 2018. So the last one was still as of 1980. So that is how long some laws here in the Philippines can get amended. Unless, of course, that if it's appropriations or emergency bills. But usually, laws here in the Philippines take time. So therefore, the lesson from the Philippines experience is if you're creating a law, you should be able to empower the executive agencies already to craft the rules that they need, but they must be able to have that leeway to be able to create or to implement it. So thankfully, our regulatory framework, the laws that we have, gives us the flexibility to adapt to the evolving challenges, especially in BO, that it's always evolving. So drafting effective regulations is not, of course, without its hurdles. So early versions of our beneficial ownership transparency policies actually sought to make BO data publicly accessible. The first memorandum circular released by the SEC on BO is not actually did not make BO confidential. But due to pushback, privacy concerns, especially on privacy concerns and legal challenges, we had to make some significant revisions, including limiting access only to law enforcement. So while we advocate for transparency, we also had to balance this with individual rights to privacy. Also, we also faced our certain issues in three main areas that I would like to share as provided by our stakeholders. First is about the processes. Our stakeholders highlighted the burden of frequent submissions, which we addressed to streamline the timelines. So when we're crafting our policies, we have to listen to them, take note of the realities on the ground on how long it takes for them to be able to submit something to get the company service providers from their clients, and to make a rule really that is feasible in practice. Also, there are questions about liabilities. So there were questions about penalties for false submissions that led to clarifications about the accountability, or who will be liable. Will it be the company service providers? Will it be the BO themselves? Will it be the company? So it is important when you're creating legislation, whether primary or secondary, that it will be clear already who will be liable. Next is about the sanctions. Of course, the Philippines is a developing nation. So in as much as we want to rival, or at least be comparable to developed countries in terms of penalties, we can only set the penalties to the maximum that is allowed to us by our primary legislation. And to go around that is that we included non-financial sanctions such as disqualification of directors, disqualification of beneficial owners, among others, and the suspension and eventual dissolution of the company. So as to primary legislation, all laws here adhere to these two judicial tests in the Philippines in order for it to have a valid delegation. One is the completeness test, which ensures that primary laws are comprehensive, and the second one is the sufficient standard test, which means that there must be clear boundaries for delegated authority. So these principles safeguard the integrity of our regulatory system and the rulemaking power of the government to keep us in check, while allowing us room for necessary adjustments. So based on our experience, we would like to recommend that primary legislation must have already clear definitions on beneficial owner, or at least the ones that are prescribed in international standards. It must already have the data sharing mandates to allow the regulators or the government agencies to share. And the enforcement mechanisms and the sanctions must already be provided there as far as practicable. Other provisions like specific threshold, detailed processes, and other implementation matters can be delegated to secondary legislation to allow flexibility. Because we know that the standards keep on moving. Like, for example, what was shared a while ago by our colleague from EITI, they are proposing for another threshold. So the ones that are implementing those must have the flexibility to do that. And definitely can't be by primary legislation, which takes time, at least for our experience. So our BO journey has taught us that also that strong leadership and collaboration are crucial. So the SEC, our experience, we benefited from broad government support, as I mentioned a while ago, including partnership with organizations like UNODC and Open Ownership. This partnership help us develop context-specific solutions and foster cooperation. So our moving forward, we also are able to conduct policy reviews that is central to our strategy. We aim to refine the thresholds, the processes, and ensure that our systems are responsive. So as a reaction to the guidelines provided, we see that the guidelines are a vital resource for policymakers and legislation, including civil society. They provide the framework for drafting effective laws and implementing reforms. So in the Philippines, we can say that it is good. This one will serve as a good guide for parliamentarians and in our case legislators in terms of crafting sound BO policy reforms. So on one last note, we would like to emphasize the need for to really strengthen the regulators. The transparency or BO transparency reforms at the beginning really needs a champion. So you have to empower your champion so that they will be able to really go through the processes because there are a lot of challenges, especially in the beginning, not only from the government, not only from external evaluators like the FATF, but also from the public. As I've said, the SEC have faced significant legal challenges in implementing its BO reforms. So if you want to be able to support that, to introduce that reforms, you should support the agency that will implement it. Give them the authority and the power to be able to do something about it. And of course, maintain oversight, of course. So with that, I'm glad to be able to share our experiences.
Thank you very much, Attorney Daniel. You've raised a lot of critical points there, which are comprehensively covered in the guidance that's been discussed today. I think I'm just going to say something quickly before I invite our colleague from Zambia. I think one of the key points that you make is that of iteration. Indeed, standards keep changing. The approaches that criminals, so to say, use to move funds from point A to point B, to structure, companies across different jurisdictions, it keeps getting even more complex. Human beings are getting more intelligent. There's the use of AI. So it's really critical, as you have mentioned, to create room for flexibility, for iteration, for improvements, preferably by giving powers, as you said, to the relevant authority to create subsidiary legislation, because as we all know, it's usually difficult to amend primary legislation. So that's a very critical point that you've raised there, and all of that is covered comprehensively in the guidance that we're speaking about today. So thank you very much for sharing those points. I think another key thing you mentioned was the data sharing mandates. We have seen that lots of government agencies in different countries collect this information, but when it's time to share the information with people that actually need to use it, especially competent authorities, they would usually have that legal barrier that they don't have the mandate to actually share it. And then you then question, what's the point of collecting information if it cannot be shared with the right authorities for it to be used for impact? So that's another critical point. I could go on with your presentation, Attorney Daniel, but in the interest of time, I'm going to stop here with a big thank you to you for sharing those points, and also with the pleasure of inviting Mr. Chawa Chilufya, Deputy Registrar at the Zambia Patent and Companies Registration Agency, to share a few thoughts for a few minutes, and then we open the floor for questions, conversations, discussions with our esteemed participants in the room. So thank you. Over to you, Chawa.
Thank you very much, Favor, and it's a pleasure for me to make a few remarks regarding our journey of beneficial ownership in Zambia. So the beneficial ownership legal framework in Zambia is governed primarily by or anchored by the Companies Act, which is Companies Act number 10 of 2017, and it is administered by the Patents and Companies Registration Agency. Our journey to where we are right now started before 2017. So the primary piece of legislation, like I had mentioned, is the Companies Act. There are other pieces of legislation, for example, the Financial Intelligence Center Act, and there have been mentions of beneficial ownership in acts that are administered by the Deeds Registry, but primarily we anchor and we host the central registry. So in terms of getting to where we are from the legal front, we started the journey quite some time back, but it culminated into a piece of legislation in 2017, which piece of legislation introduced beneficial ownership into our legal regime. Prior to that, there was a bit of a confusion even from the decisions that came from our superior courts, where the understanding or the decisions, and we were meant to understand them to be so by the superior courts, was that beneficial owners were the same as shareholders. So in leading judgments, the words were being used interchangeably. And it obviously later on, you will notice in my remarks how this provided a challenge to us in the process. Now, getting to having beneficial ownership implemented in Zambia, what we had was we were primarily moved by the need to have obviously legal persons be unattractive as tools for commission of crime and for illicit inflows of finances into our money markets. And as a result, there was movement by the government to ensure that this is introduced in our legal system. When we appeared before the Parliamentary Select Committee in 2017 to support the implementation or the repeal and replacement of the law on companies and introduce beneficial ownership, one of the things that we obviously had to do was to ensure that in the process of supporting that movement to introduce beneficial ownership transparency in Zambia, we gave valid reasons for its introduction. I'll get back to this point later, but perhaps I would talk about the challenges that we've had so far on our journey. One of the challenges that we've had is clearly this is a new concept. You realize that the law might have been a 2017 piece of legislation, but in terms of reach, in terms of knowledge among the Zambian population, this has been quite a challenge. And as a registry, we have to keep explaining almost on a daily basis to everyone who registers a business and chooses a company what beneficial ownership is, what control is, what information we need from them, and why we need that information from them. And that is a challenge because there's a huge knowledge gap between what we aspire to collect and what the law provides for and what the people who are supposed to provide us that information can provide. Also, there is a challenge of tools which can be used to collect the information and share it with relevant government agencies. So we will notice that when it comes to beneficial ownership information sharing among competent authorities is a critical and important thing that should happen. But our processes for sharing of that information is manual and it's not real time. So by the time it's reaching the intended recipient, you might find that that information has changed. Also, not all key players in the beneficial ownership chain are put together in a system or on a platform through which they can easily or intelligently share information. There's also the challenge in relation to the setup or the state of our country in terms of for example, you want to provide biodata of a beneficial owner, you find that it's difficult due to the nature, for example, the addressing system. So you might not have an accurate address of a beneficial owner, and how do you confirm that address? That is a challenge. So that obviously leads us to opportunities of crafting solutions that attend to our uniqueness. How do we verify the address, or do we have systems that we can come up with as a country, or requirements that would still make us verify information on a beneficial owner without really, restricting ourselves to having a one-size-fits-all approach, looking at what we have and what other countries have. In terms of successes, I would say that we've recorded a fair amount of success as a country. We obviously would prefer to do much more, but as it stands, we're grateful for the successes that we've scored so far. We have embarked on a lot of sensitization, awareness, and training for not only our staff, but also key stakeholders. We are collaborating with stakeholders and other government agencies, and we're part of a framework of government agencies that share information, and we're able to share that information. You're also able to access information, though not segregated information, but you're able to access beneficial ownership information in the comfort of your home. We have a platform through which you can do that using our website. And those would be what we'd call successes. And we also have plans that are afoot that will see the creation of a system through which beneficial ownership information can be accessed in a smarter and quicker way, separately and apart from other information that we provide as a registry. Now, when it comes to the journey for legislating beneficial ownership, one of the things that are critical, which we realize, is the issue of definition, because we obviously came to the point of realizing that the whole beneficial ownership transparency rises and falls on having the right definition. In my earlier remarks, I had said that our superior courts had used in various decisions the term beneficial owner and shareholder interchangeably. And one of the leading company law experts in Zambia, who was practically taught half the bar on company law, his position was that a beneficial owner can actually be a company. So you can imagine what we had to struggle with when we had to present our position on the fact that a beneficial owner has to ultimately be a natural person. He was invited by our parliament as an expert witness to present his side of the argument. And we're glad that ultimately the proposed text in our bill saw the light of day, and we do have the definition of a beneficial owner to be a natural person. And probably he wasn't amused, but the good part is he's a very good lawyer who appreciates that the law is as it is. It could be better later on, or it could be his opinion. Yeah, but ultimately it is as it is. So now, looking at what we are launching today, for us, the guidance on effective legislation for beneficial ownership transparency, one of the things that we consider to be important in this particular text, or I'll address all the three of them at once in the interest of time, is that they can be useful to legislators by affording them clarity on the legislative process and elements for effective beneficial ownership reforms. So they do not need to struggle for them to look at what should constitute, so the elements that should constitute effective beneficial ownership reforms. And it will also allow the legislators to draft laws that are aligned with international standards and tailor them to local needs. In relation to policymakers, they will be able to understand as a result of these particular publications, the interplay between beneficial ownership transparency and other policy goals, for example, anti-money laundering, fair markets, etc. And they will be able to use international examples to benchmark and improve domestic reforms. In relation to stakeholders, for example, civil society, businesses, and citizens, they'll be able to leverage on transparency frameworks to monitor compliance and ultimately advocate for reforms. And the issue of transparency is critical here, and it's something that civil society would gladly ride on. They would also be able to use beneficial ownership data to ensure ethical business practices and hold authorities accountable. So for stakeholders, they'll be able to know who ultimately benefits from or controls legal entities. And that would be good for their activism, and it would be good for them to hold governments to account. And on that note, I would like to say thank you, Favor, and thank you to the organizers for giving us an opportunity to share our experiences. Thank you very much.
Fantastic. Thank you very much, Chair. I think what I'm seeing in your submissions, Attorney Darnell's submissions, and I think that of the Senator, is the point around stakeholder engagement, sensitization, not just for the private sector, but even for the staff of the relevant authority that is responsible for doing this as well. And I think that sort of amplifies or emphasizes the point around taking a user-based approach to developing laws. You're developing laws for people to comply, so you do need to engage them. That's a very critical point that you've raised. But something else that sort of came to me as you were speaking as well is the fact that when we approach the legislation for BOT reforms, it seems like most countries approach this from a disclosure perspective. Could we create laws that will enable the disclosure? But I think what we're beginning to appreciate is we need laws that don't just enable the disclosure of BO information, but enable the updating and maintaining of the information, the storage of the information, the sharing of the information, and the use of the information. So I think that's another critical point that sort of came through for me in your submission. But as you rightly said, what we're really hoping that these different tools that we have put together would be as useful as possible and would make, you know, the lives of implementers much easier. So you don't have to reinvent the wheel. There's lots of guidance around how you should do this, what should go into the legislation, you know, the sort of things that parliaments could do to support this process for an extractive industry country, the sorts of things that you need to be thinking about. For example, adopting maybe a risk-based approach to thresholds, which Ghana has done. So they would do, you know, a lower threshold for companies that are operating in the extractive sector. So there's so many, you know, key points that are flagged across these 3 different guidance documents that, as you've said, we're really hoping will make the lives of implementers much easier. So thank you for flagging those points there. So colleagues, we're going to proceed to the Q&A, which I think is very important. We already have a couple of questions in chat, which is fantastic. I think there was a question from Maria Estrada from Mexico. You asked a couple of questions, which I believe Senator Lewis has already responded to. So thank you for that clean exchange there in chat. We do have a hand raised. So colleagues, this is a Q&A session discussions. We have a fantastic pool of speakers today, so please feel free to ask questions. And if you do, please introduce yourself, just your name, country, agency, and if you want to direct your question at one of the speakers, please feel free to do so. Ian Rose, the floor is yours.
Hi. Good morning. Can you hear me?
Yes.
Can you hear me? Yes. Okay, fantastic. Well, first of all, thank you for the organizing organizations. This has been a great seminar thus far. I guess I wanted to ask some of the panelists, and more than one of them have already discussed this, is the issue of sharing, to what extent the benefit. Oh, I'm sorry. My name is Ian Rose, and I'm from Tetra Tech ARD, which is an implementing organization of development assistance programs from, say, USAID and other donor
Sorry, Ian,
institutions.
for interrupting you. Forgive me. Senator Lewis has to leave shortly, so I'm keen for us to do a very quick group photo before he leaves, and then you come back in with your submissions, please. So Yasha, my colleague from EITI on the call, will lead the group photo. Yasha, over to you. Let's see how we can do this quickly, and then we hand back to Ian.
Thank you so much, Favor. If I could ask for everyone to switch on their cameras and put on your best smile. Thank you so much. So because we're a lot, I will start with the first batch. So I'll count up to 3, and then if you could smile, that would be perfect. So 1, 2, 3. And again. Jerry, your camera is off. If you could switch it on. Thank you very much. 1, 2. Okay, next batch. 1, 2, and 3. Thank you so much, Favor.
Fantastic. Thank you, Yasha, and thank you for everyone on the call for cooperating there very quickly. Happy to hand back to Ian to continue with your question. After Ian, we will take Michael Barron. I see you have a question in chat. I can give you the floor to also share. Ian, back to you, and thank you for considering. Over to you.
Yeah. I guess Senator Colosio and the gentleman from the Philippines touched on this and in the chat, but the extent to which it's the elephant in the room, the beneficial ownership is shared to the public. And I feel like there's this sort of assumption, like it's black and white, like it's shared or it's not shared. But it seems to me that the question could be framed differently in terms of a filter, meaning maybe the public only sees the name, but the financial institutions see, for example, the addresses, which was mentioned by the gentleman from Zambia, I believe, or, phone numbers or social security numbers. So it seems to me that the paradigm of discussing this issue shouldn't be whether it's public or not, but maybe a more subtle distinction of filtering the information. So if I go on the public portal, I only see a limited amount of information. Is that something that's certain that the legislative models are looking at, maybe even the guides that you've published or launching today? But I'm just wondering, since the senator and the gentleman from the Philippines discussed this, shouldn't we be talking about a middle ground? So that's really my question on this issue.
Hello. I agree with you. That could be a solution. I think for some they called it a tiered approach to in the matter of having some info publicized and some redacted. I think that's one of the solutions that can be, or the discussions that can be had as an alternative to just a black and white public or non-public, because at the end of the day, the making the of course we know the benefits of making BO information public. First, you tap on others to be your validators, the media, the people, to assist you in making sure that the data there are really what they should be. And at the end of the day, it's also about transparency. So if the more data that is out there, the more transparent it is, the more the benefits of being transparent is achieved. And I think, yeah, I agree with you. But at the same time, even that tiered approach needs to be legislated. There must be a rule where you allow a tiered approach in terms of divulging data, because at least for the Philippines itself, even the names are personal information that have to be protected by data privacy.
Thank you, Daniel. And I'm just going to add a couple of thoughts there to your question, Ian. Indeed, in the guidance document, I'll specifically refer to the open ownership guidance. I think from pages 27 to about 31 or 2, there is a section there on sharing of and access to beneficial ownership information. And when you do get the time to digest the content of that, you would appreciate that what we've done in terms of approach is to acknowledge that BO information inherently comprises personal information. And it is then critical that when you're legislating and designing your access regime, you think about the bearing it has on privacy. And what we also encourage countries to do is, and this is a key point that Karina made, you want to ask yourself, why are we doing this? What is the policy objective? Is it purely AML-CFT focused, or is it because our citizens just do not trust the government at all? So this is our attempt to also encourage some sort of relationship or trust between the people and the government, especially on public matters like public procurement, which we know, is plagued with lots of fraud and conflict of interest. So, depending on why you're implementing this, you could then, use that to influence who should have access and to what they should have access. So, for example, FATF says competent authorities should have timely access to accurate, adequate, up-to-date BO information. Your financial intelligence units, your anti-corruption commissions, those investigative bodies, give them access to everything they need to actually inform their investigations. And I'm pretty sure there are internal processes on how that information is used. So it's actually respected in line with, international standards. But when you then progress from competent authorities to, say, the public or to civil society, you could give civil society access depending on why you're implementing these reforms. But for example, you wouldn't give them phone numbers, addresses, like you mentioned, unique IDs and things like that. To the public, I'll give an example. In Namibia, the law specifically says the public can access BO information, but it's limited only to the full name of the beneficial owner and the nature and extent of beneficial ownership. So the conversation actually, especially in the guidance that we've published, is not so much about public versus non-public, but it's what is the best way to give access to a set of people that would help us achieve the ultimate goals that we are trying to achieve, be it anti-corruption, be it procurement transparency, be it AML-CFT matters. So that's sort of the approach. And I'll be honest with you, this is probably one of the most contentious elements of the conversation, because sometimes you would get pushback. And I think this is a point that Michael Barron makes in his question. You would get pushback from private sector, and they would say, why are you putting my information out there? This is a business, it's a private family business. What is the purpose of all of this? So that's why it's important that every country identifies the policy objective. Why? Because that would inform some of these difficult conversations that need to be held. So I'll stop there so I don't monopolize the conversation and hand over to Michael Barron. You have a question in chat. Would you like to come in and just share, or should I just read it from chat?
No, I'm quite hello, Favor. Thank you for giving me the opportunity. First, yes, my question is related to this conversation, and just like to pick up on Ian's point that, yeah, good practice at the moment is where a country makes its beneficial ownership publicly accessible. For example, I'm sitting here in the UK. We have a publicly accessible beneficial ownership register, you can search it and find my name on it. Because I am the beneficial owner of a UK registered company, but you can't find all my personal details on there. You can only find a subset of the information that I'm legally obliged to supply to the register. And you mentioned Ghana and Namibia. I should say I'm an independent consultant which have been involved in helping probably more than 20 countries now deliver beneficial ownership projects, including being part of the team that helped Ghana with its register and its risk-based threshold that you referred to earlier. And earlier this year, I was supporting Namibia as well. My question, so with this debate that's raged almost since beneficial ownership registers were first proposed, but especially since the 2022 European Court of Justice ruling, there does seem to be a pushback against public registers. But on the other hand, as this conversation has shown, and as numerous papers and reports have shown there is increasing recognition that beneficial ownership information can be used across by all kinds of people for all kinds of different reasons, whether it's anti-corruption, whether it's to improve transparency in supply chains, in public procurement, and so forth. And an important stakeholder in all of this is the private sector companies, who, at the end of the day, provide the basic information, but also where there is a public register can be important, and there is evidence to support this, are major users of that data to manage their own risks. And so bringing them on board, so my question is, how can they be engaged, or to what extent are they engaged already in the legislative process to gain their support in the argument for public registers? Thank you.
Thank you. Very critical question there. And I'm keen to invite our country representatives. I don't know, Chair, Attorney Daniel, what your experience was when it came to engaging with stakeholders, particularly private sector, on this particular topic. I know there's usually pushback, but what did that look like? How did you navigate that, just within the context of a question that Michael has posed?
Thank you very much.
Sorry.
Go ahead. Okay, so when it comes to the private sector, I must say it's a very difficult of the stakeholders. It's the most difficult one to deal with, especially in the context of a country such as ours, which is a developing country. So they wield quite a lot of authority. So if you have to choose between beneficial ownership and the investment that they're going to bring in the country, most likely the citizens who believe that they'll be given a job, the leadership which believes that it is delivering on the need to provide jobs to the people, you know which side they would lean on. So it is a very difficult conversation. We had a very interesting situation where someone wanted to register a business in Zambia, quite big out there. And the challenge that was there is they didn't want to supply their personal details, their passport number, which is a requirement on our subsidiary legislation that you must provide that. Their argument was privacy issues, obviously, and the need to safeguard identity theft. So it was a back and forth. But the challenge in that was that this person's investment was seen to be very important and necessary to have, and they were going to employ thousands of Zambians. And then there is this requirement for them to reveal that particular part in our regulations. So given an opportunity, someone who has power to change that piece of legislation will have to think, should we keep this requirement or should we change it to allow for us to have easy FDI, for example, without encumbering those who want to invest in our country with these requirements. So on a practical level, I think we've faced that challenge, especially in our setup where we do not have our information segregated. So if you want to access information on our register, you're probably going to access everything. So for us, it's a learning curve where we now need to come up with a system where you can access certain information and block out other information and only give it to specified stakeholders or to competent authorities, and then leave out certain information. So that has been our issue. It's really a challenge because those who invest a lot of money, they wield a lot of authority and influence. So this has been a challenge on our part, and it's good to hear from you, Favor, and others on how they've gone around this. Thank you.
Thank you, Chair. Attorney Daniel, did you want to come in?
Yeah, well, at least for the Philippines, our BO data is really not public. It's really only made available to law enforcement authorities. But if I can give my opinion on how we've engaged the private sector in terms of BO in general, the concept of BO, when we introduced it a few years ago, it was marred with a lot of legal challenges. Even some petitions for temporary restraining orders, among others. So this concept, which brought about change in what was being done, really was it's not really something that is welcome initially, but it's incumbent for the regulators or the ones that are um, advocating for it to really go out there and conduct the outreach campaign, make it more easier for the stakeholders to understand, because they're not going to support it if they don't understand. And I'm sure all good businesses, those that have good intentions, have no problem with with sharing data, or if it's required, um they don't it won't be that much of a bother. So I think it's really just get going out there, advocating and saying that, this is this will the benefits of what are the benefits of being public, what are the benefits of being transparent, among others.
Great, thank you, Attorney Daniel. I think it's also important in those engagements to even clarify with private sector that when we say public, we don't mean every information. If you submit 14 data fields to the SEC, they're going to publish the 14 data fields. It's usually a subset of that information. But I think, Michael, it's the only way is just to engage them from the beginning. Once there's a draft legislation or even an intention to amend the law, especially if it touches on the access regime, you want to engage with them as soon as possible and just sense check, what do they think about this? Do they understand the why, the potential benefits, even for due diligence purposes? I mean, I'm a lawyer by practice, by profession, or training rather. And I remember a few years ago when I have to, conduct due diligence processes for like mergers and acquisitions, I would literally have to go to the Corporate Affairs Commission, retrieve lots of files, because most of the companies are like old companies that have been in existence for like 20, 30, 40 years. So I have to, retrieve the files and plot the shareholding structure, the historical shareholding structure of that company from the date it was incorporated to the date we're doing that transaction, just to find out the chain of ownership of that company, which I can easily tell you was a Herculean task for us to do. So even for companies as well, if you're able to access this information, it really helps to really understand who you're doing business with. So I think it's possible that a lot of the conversations that we have on BOT, is probably centered around corruption or anti-corruption. How about we balance the conversation around the value to talking about the benefits for private sector? If we're able to say, this is what it means for you, this is the value it's adding to your work and to your business, that could be another way to sort of advocate for some level of public accessibility within reason. But yes, I'll stop there. We have some more questions in chat. I think there's a question here about minors. What should be the legislative approach? This is from Jean Etienne. What should be the legislative approach or the good practice when the beneficial owner is a minor or an incapable adult? I'll share a couple of thoughts, but whilst I'm doing that, I'm just going to ask one of my colleagues to kindly post in chat the blog that we posted last year, September, on minors as beneficial owners. I think the advice that we have given when we sort of engage with countries, I know Zambia has actually asked us this question in the past, and what we sort of said is it's important to collect the information because, I mean, let's say the legal age in a country is 18 and, the individual in question is 17 years, 11 months and 7 days. They're going to be an adult very quickly. So it's important to collect the information as the relevant authority, whether the person is 1 month all the way to, very, very close to 18 years. But that information ideally should be protected. That's the sort of information that you should automatically have some sort of internal regulation to protect for obvious reasons. But beyond that, you also want to collect information about the guardian. Because, for example, if the minor is a 2-year-old, there is no way on earth that a 2-year-old is making decisions for a company or receiving and spending the financial benefits or profits that, that company makes on a yearly basis. There is a guardian that is responsible for that minor. So if, for example, that particular company is found wanting or it's a part of some sort of scandal, it's easier for you to actually hold someone to account when you have information about the guardian, because it would be the guardian in that case that would have dispensed or used those funds for whatever questionable activities. So our general advice is, yes, collect the information about the minor, but protect it. Do not for any reason make that public. But collects also information about the guardian. And that's a standard thing, even with banks. I mean, when I was underage, my mom would create a bank account for me. And then once, I become of age, I then go to the bank and say, I want to start running things. So that's the standard practice, even in like the financial sector. So I think that can also be easily applied in this context. Isabel, I know you have been supporting all of this behind the scenes. I just wanted to check how we're doing on time so that I know when to start drawing the conversation to a close.
Unfortunately, we are just a little bit over time already. So we could perhaps try to capture all these questions and share some answers via email to those who have registered.
Yeah, I think that's a good idea. Thank you. I think there's still a couple of questions around the EITI approach to public access, and one or two that I may have missed as well. So we will collate the questions that have been unanswered. We're going to provide responses to them in collaboration with NDI and EITI. And I think at this point we are going to wrap up the conversation. Allow me to say a big thank you to all our speakers, starting from the Senator to Gay Ordinas from EITI, to Karina from NDI, to Attorney Daniel from the Philippines, and also to Cherry from Zambia. Thank you all so much for joining, colleagues. We all know that today's discussion has really shown that while the path to beneficial ownership transparency is complex, it is also essential for building trust, for combating corruption, for ensuring fairness in our economies as well. And truly, with the right tools, such as the resources that we are launching today, with the right collaboration and commitment, we can turn challenges into opportunities and create lasting reforms and benefit for everyone. So I'll encourage all of you, let's take what we've learned here today and continue driving forward the transparency and accountability that our societies deserve. Thank you all. Please use the guidance, share the guidance, give us feedback on how helpful it is or unhelpful. And yeah, we'll just keep in touch and communicate with all of you subsequently. So thank you once again. Enjoy the rest of your mornings, afternoons, and evenings, wherever you're calling from. Thank you and goodbye.
Thank you, Favor.
Bye, everyone.
Favor.